We're going to go ahead and get our meeting started for the Planning Commission for July 29th, 2024. It is now 6 o'clock. I want to call roll call, please.
Commissioner Engelke,
Here.
Commissioner Ware, Commissioner Kirkley, here. Commissioner Vidal,
Here.
Commissioner Stokes, Commissioner White, Commissioner Carter,
Here.
Commissioner McGann here.
Thank you very much. All right, so if everyone will stand, we'll do our Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I hope all of the commissioners had a chance to review the minutes from our last meeting on June 24th. If there's any corrections, please let us know. Otherwise, do we have a motion? We have a motion. Do we have a second?
Second.
We have a motion and a second. Any discussion? Roll call, please.
Commissioner Kirkley, Commissioner Vidal,
Yes.
Commissioner Stokes,
Yes.
Commissioner White, Commissioner Carter,
Yes.
Commissioner McGann, yes.
Okay, before we get started, I just want to remind all the commissioners to make sure they pull their microphones in front of them and turn it on and off, so that way people that are watching us can hear us as we speak. There is no old business, so we will move on to our new business. First case before us is case number 2024-067. It's a site plan review for a parking expansion to the existing site at 604 Expressway Drive on land consisting of 36.21 acres under planned business park zoning being developed by Rye Products, Fisher Arnold Engineer. And I will turn this over to our director for his presentation.
Thank you. Next slide, please. All right, so here's the aerial view of the property. It's a large building at 601 Expressway Drive, and there is some parking right there, but the goal of this is to get more parking for this building on the north side and the south side. Next slide, please. And then so that's just zoomed out view of the surrounding area. Next slide, please. And as we said before, this was this is in the planned business park zoning. That's not common zoning in Horn Lake, but this area basically it's designed to be a large, somewhat industrial, somewhat nicer type of zoning. Next slide, please. All right, so the existing site plan is here. We just wanted to show the current plan on file, showing the building, showing the open grass area, and the parking. So the parking is currently located in the northeast corner of the site. And then if you look down, currently at the south side of the building, there is some paved area there, but it's primarily for loading and unloading. And if you notice there where you got trucks coming in to load and unload, there's no regular parking over there. And they had space available for that parking. So if you go to the next slide, colored there in the dark areas, that's going to be the brand new parking. So Rye Products is proposing 2 parking expansions at their Horn Lake Distribution Center, and the locations for the parking expansions are marked up there in that northeast part and then the southwest area of the lot. Next slide, please. All right, so we got a zoomed in screenshot here of the northeast parking expansion. The parking expansion will add spaces and parking islands with landscaping east of the existing parking area. Next slide, please. And then the parking expansion will add spaces and parking islands southwest of the primary building, allowing for parking access on the south side of the building. And as you can see there, they're adding regular parking spaces in that space over in the corner. Next slide, please. All right, so for the grading and drainage plans for the parking additions have been submitted with water draining to the existing stormwater catchment to the north. Next slide, please. And then grading and drainage plans for the parking additions have been submitted in this area with water draining to the newly installed inlets. So drainage has been accounted for on both parking lots. Next slide, please. And then as far as the landscaping goes, they have included that. So there will be 3 types of trees and 2 types of shrubs located on the landscaping plan for the northeast lot, and we looked at the species and they're okay. Next slide, please. And then same here, they made sure to add landscaping to that southwest lot as well, and everything looks good on them. Next slide, please. And so basically that was it. We just checked for the drainage, just checked for the water permeability on the lot, and then everything we looked at didn't cause conflict with more water buildup anywhere, landscaping issues, and they had plenty of space existing on the lot to just add more parking. And that concludes the presentation.
All right, does any of the commissioners have any questions for our director?
As far as like the specific material, I believe the representative here could answer that part.
If the representative's here, you can come up and just state your name and address.
Michael Rogers with Fisher Arnold, 9180 Crestwind Hills, Memphis, Tennessee. It will be asphalt, sure will.
Okay, does anybody have any other additional questions, either for the director or the applicant, or the applicant's representative? Okay, thank you, sir.
Thank you.
All right, so do we have any discussion or a motion?
I'm ready to make a motion.
All right, go ahead.
Review of case number 2024-067, site plan review for a parking expansion to the existing site at 604 Expressway Drive on land consisting of 36.21 acres under Planned Business Park zoning, being developed by Right Height Product, Fisher Arnold Engineer, and the Planning Commission approved the presented site plan.
We have a motion to approve. Do we have a second? We have a motion and a second. Any other discussion? Roll call, please.
Commissioner Carter,
Yes.
Commissioner White,
Yes.
Commissioner Stokes,
Yes.
Commissioner Vidal,
Yes.
Commissioner Kirkley, and Commissioner McGann, yes.
All right, it has passed. Thank you, sir. On to our second case. Case number 2024-092 is a plat revision for tracks 1A, 1B, and 1C in Shady Grove subdivision by applicant Jones Davis and Associates, consisting of 3 lots zoned AR on approximately 10.1 acres. And again, I will turn this over to our director.
Thank you. All right, so I'll start off with the purpose of this case. The current subdivision consists of 3 separate parcels of land. And so the applicant wishes to move the property line between 4265A and 4265B to make it where the driveway to the house and garage at 4265A is on one parcel, and the driveway to these structures branches off the easement from one property, crosses into another property, and then enters the correct property. So the current plat and current site conditions may cause complications in the future if any of the parcels ever go for sale, or if there are any disputes between neighbors regarding property access. And hopefully everybody got the like the PDF of the plat and was able to zoom in and look around on it to see the peculiarities on this one. For the same reasoning, the applicants also agree that the parcel at 4265B should have 2 access points to the ingress-egress easement, which is why the proposed property line is not a single straight line, and we can get into that later in the case. Next slide, please. So this might be easier to, maybe a visual might be easier. Here's the aerial view of the properties. It's 3 properties at 4625, and as it got subdivided over the years on that same lot, in order to get access to the 3 houses, this is the plat lines that were drawn up, and then the 3 houses just got labeled as A, B, and C. Next slide, please. And that's just showing the current zoning. It's all AR, so this is important. So when you do the platting process and you put houses in there, you know that, you know how far the setbacks have to be. Next slide, please. And if anybody wants to go back to any of the images, just let me know, because I know this one might get kind of confusing and we might have to go back and forth on this. Here's the current plat that's recorded. It is a little hard to see. That's the actual scan of the plat on DeSoto County GIS. And maybe we can just go back to this if anybody has any confusion, but I'll just do a quick little run through. Currently, this is what's called a flagpole lot, where you got the big part of the lot way at the end, and then a skinny part of the lot connecting towards the road, and then other lots kind of sandwiched in between that. And so basically, since it's all private property, you have to specify where the easement is when you do the plat. That way, one property owner doesn't block access to the driveway for all the property owners. And so that's why this plat was drawn up in this way. Next slide, please. And so, yeah, I'll go through the wording of it here. The current plat has tract 1C connecting all the way to DeSoto Road. The skinny, or the pole part of this lot connecting to the road, is labeled as an ingress-egress easement, so that the residents of tract 1A and 1B can have the right to drive to their homes, since they have to drive on tract 1C to get to them. So additionally, there is an ingress-egress easement located on tract 1B, which branches off of the other ingress-egress easement. It appears that the purpose of this was so that the driveway to tract 1B could be built to branch off of the tract 1C driveway. And regardless of the purpose of the original plat drawing, the reality is that the existing driveways and current layouts is not practical, or it's not as practical as it could be. Next slide, please. So the solution to this is this proposed plat, and it was kind of oriented in a different way, so that's why it's flipped around in the images. But hopefully this one's going to be a little easier to follow. If you look at the tract 1C lot, you notice that it has a shorter driveway, and it stops, the official property line stops there where it's touching tract 1B. And then so what that does is it gives Tract 1A the full access to the roadway, the public right-of-way. And then if you go to the paved driveway, swirling down to the house and the shop, notice that the original property line was cutting through the driveway, splitting the driveway between the shop and the house. So what they did this time was move that property line towards the south on the south side of the driveway, and there's a little bump out, which might look kind of weird at first, but the purpose of that was so Tract 1B could have access to the driveway on both Tract 1C and Tract 1A. And if anyone has any questions on that, just let me know. Next slide, please. So here's the wording of that explanation. The proposed plat also shows the current problematic property line as a dotted line cutting through the driveway and placing the shop and the rest of the driveway in the neighbor's yard. This proposed plat revision aims to place all structures on Tract 1A fully within the boundaries of Tract 1A by shifting the property line south of the driveway and the shop. The proposed plat also shows a reduction of the pole portion of Tract 1C to allow for Tract 1B to have direct access to the ingress-egress easement on both Tract 1A and Tract 1C. It is our understanding that the applicant in Tract 1B is more comfortable having that extra access just in case there are difficulties with the resident at Tract 1C. And next slide, please. So this is the zoning district regulation chart, and this just shows that since it's an AR, it's got to have the 1 acre minimum lot. And each lot will be larger than 1 acre after this is redrawn, and the width at the building line requirements will be met for each lot, and the minimum yard requirements will be met for each lot. Next slide. All right, so just to get in all the regulations required for the easements, for this one here, dictating that easements of at least 10 feet in width shall be dedicated on each side of all rear lot lines, and at least 5 feet on each side lot line, and at least 10 feet on all lot lines adjoining a street. The plat does not conflict with this requirement. Next slide. And then so this one's about easements for any streams or surface drainage. The plat does not appear to conflict with this requirement as there are no major streams within these parcels. Next slide, please. And so for the street regulations, there are no continuing existing streets within this current plat, so same with the new one. The plat does not conflict with this requirement. No new street names are proposed, so it doesn't conflict with letter B. And then it does not conflict with the requirements for it giving due regard to topography and other physical features. So it passes those ones. Next slide, please. All right, so then in letter D, it says the right-of-way widths and location of major and collector streets shall conform to the right-of-way widths and location of such streets designated on the transportation plan. This plat does not conflict with the right-of-way widths or locations in the transportation plan. And although the plat technically does not show an actual right-of-way, the proposed ingress-egress easement is 50 feet wide, which is an adequate width for this purpose if it ever does get converted into a right-of-way. Letter E says the minimum widths of street and road right-of-way measured from lot line to lot line shall be as shown on the transportation plan, or if not shown on such plan, shall not be less than the following. The minimum right-of-way for local streets shall be 50 feet, except in cases where the topography or special conditions make right-of-way of less width more suitable, and it does not It does not conflict with this requirement as I said earlier, the ingress egress easement is shown to be 50 feet wide. Next slide, please. All right, so more street regulations. Letter F says the angle of intersection between streets should not vary more than 10 degrees from a right angle. This plat does not conflict with this requirement. The minimum corner radii at street intersections shall be 20 feet. The plat does not conflict with this requirement. And street jogs resulting from failure to align streets on either side of the intersection are prohibited. No street jogs have been provided or proposed on this plat, so it passes that requirement. All right, and then letter I says cul-de-sac streets may be provided if proper access is given to all lots from a dedicated street or court. All cul-de-sac streets shall terminate in a dedicated right-of-way space having a minimum radius of 50 feet or other satisfactory arrangement for turning of vehicles. A cul-de-sac street shall not exceed 500 feet in length. So the plat does not show any cul-de-sac. However, cul-de-sacs exist for these exact kind of subdivisions that contain a singular roadway that terminates at one point. Since this road is a private driveway and not a public road, a cul-de-sac will not be required. However, it is highly recommended in the future that the existing ingress-egress easement be acquired by the city in order to become a public right-of-way with a cul-de-sac for vehicles to efficiently turn around in. And this is good for citizens as well as emergency vehicles and fire apparatus. That's exactly why cul-de-sacs are designed the way they are. And even though the road would be over 900 feet long, it would still make sense, even though we have the regulation that cul-de-sac streets shall not exceed 500 feet in length. So that's just to think about for the future. The planning department right now does not advocate to push for this tonight, but just way down in the future. Next slide, please. All right, so for the bulk requirements, flag lots shall have a minimum of 50 feet of frontage on a road built to the city's technical standards and maintain that minimum width along the entire pole portion of the lot. It meets that requirement. The acreage contained within the flag portion of the lot must meet the minimum size requirements without considering the acreage contained within the pole area. So it meets this requirement because that bigger part is over 2.5 acres. No structure shall be erected within the pole portion of the lot. Meets that requirement as no new structures are being proposed in that driveway area. Number 5, the length of the pole portion of the lot shall not exceed 250 feet and may require special conditions relating to fire safety, including special fire turnaround areas, sprinklers, or other requirements set by the fire marshal. So it technically does not meet this requirement. The pole portion is at least 335.18 feet long. However, please note that this cannot be fixed unless the city acquires the pole portion as a city right-of-way and then paves that out to be where fire apparatus can turn around. So we are recommending that that part be waived and the plat be passed as is, drawn as is. Number 6 says driveway shall be a minimum of 20 feet and constructed with an all-weather surface approved by the fire marshal. It meets this requirement. We interpret this as meaning 20 feet long rather than 20 feet wide. So we see no issue there. Next slide, please. So in conclusion, planning staff concludes that this is a reasonable revision to the existing plat. The plat that is already on record does not match the existing site conditions, and right now it may cause complications with selling properties or accessing properties. So while the most logical solution to this problem would be for the city of Horn Lake to acquire the main ingress-egress easement and convert it into a public right-of-way and pave it to the correct mandated regulations, the proposed plat you're seeing tonight is a temporary solution that can be currently implemented while the city works on securing funds to fix this subdivision at a much later date and time. And that concludes my presentation.
All right, thank you. So I appreciate the information. I do have a question, and then I'll open it up to others. As I'm looking at this, and I see that where the original property line was, and now where they're wanting to move it, are they wanting to move all this because the shop is is in track 1B, and it needs to be in 1A because this shop was built on the wrong, or at some point, they may have been the same owner and it got built that way?
Yes, so from what I remember, when this was brought to our attention and they walked into the office and showed us what was going on, that's my understanding. A lot of this was to fix the fact that the shop was on a different piece of property as well as a significant portion of that driveway. And so in that image right there, that dotted line the dotted line's the current property line, so shifting it over to the south would fix the issue where now the driveway and the shop is all on one piece of property.
Okay. And are all three owners in agreement with this plan?
I believe two of them are here tonight, and
Okay.
I believe the third one, from what I understand, is aware and is okay with it. But just to be sure, you might want to ask the applicants here tonight.
We'll call them up here in a minute. Does anybody have any questions for Andrew?
Well, it looks like the driveway ends before you get to track C. How are they gonna get back there to their property? If the driveway ends,
It goes all the way to the house. It's just the way the drawing is. Because but, look, hey, Claire, here you go. I got a map put up. It goes all the way to the house, down at the bottom. Yeah. Yeah, that's what I was looking at, so. Any other questions for Andrew? All right, the applicant's here. We just one at a time. I mean, however y'all want to do it to best explain how this is.
Ladies and gentlemen.
And just give me your name and your address.
Steve Holland, 4625A DeSoto Road.
All right, so you're in that first one closest to the DeSoto Road.
Yes, sir.
Okay. Go ahead. I just wanted to make sure that the reason we're trying to move this is because the shop was on the second track.
Right, so me and my brother-in-law both, when this thing was first subdivided, were under the impression that my driveway the line was on the south side of that driveway. But when my son-in-law and daughter bought the house in the back, he's the one that brought the attention. He said, you know your driveway and that shop ain't on your property. I said, you're crazy. And I mean, even Mr. McCracken came out and did the inspection on it, and he missed it too.
I've been in real estate for 20 years. I've seen all kinds of stuff and things happen. That's why I was more asking, that's why I was asking the pointed questions, because typically when we see this, it's either by accident or whatever, or both, there was, the same person owned the same property, built it, and then loses it or sells it off and then doesn't realize they put it on the.
From my understanding, when I was told, I actually did all the legwork on this in 93. And at the time, I wasn't in City of Horn Lake. I was I was in Walls. I come here and y'all said, no, you got to go to Hernando. I go to Hernando. I said, no, you got to go to Horn Lake. I said, I'm not in Horn Lake. I'm in Walls. I'm in the county. I mean, it was a fiasco from the beginning. But from what I understood about that thing, that easement all the way up to the very property line, that 50-foot, that's actually Shady Grove Road, a public road. That was my understanding. That's why that 50-foot easement all the way back to those three lots. So, I mean, this will take care of everything. I'm getting old and I don't want to die and leave my kids with this mess. So this will take care of everything. And then, because the reason why the lines do zigzag is Mr. McCray has given me the land. And it's, to minimizing how much he's given me it's the reason why it's doing that.
I understand that.
I'm probably
Anybody have
talking too much, don't I? Anyway.
Any
You
questions,
ask-
any questions? Well, I mean, I'm just saying, I understand this, it's better to fix it now instead of
Yes, sir.
finding it out later. That is very true. Any questions for the applicant?
And your brother owned the second piece B,
Yes, sir. He owns Lot B. Yes, sir.
and he, both of y'all in agreement? pretty much?
Yes, sir. And my son-in-law and daughter own the back lot, and they're 100% in agreement.
Any other questions? Thank
Kind
you,
of
sir.
confusing. I got confused watching it myself, but. Y'all
Well,
have
I
any
figured
more
the shop was was what kind of triggered all this. That's why I was asking the
Yes,
pointed
sir.
questions
Yes,
with
sir.
all the, okay, thank you.
No, y'all have a good evening.
All right, do we have any other discussion? Or do we have a motion? Oh, do you want, oh, I'm sorry, he was just, I think. I was getting up here, but if you want me to. No, I mean, if you want to come up here, you. Okay, yeah, just go ahead and state your name and for the record, and we'll just we'll do this.
Gary McRae, I'm at 4625B
You're in
DeSoto Road.
And you're in agreement with this plan?
Yes,
Okay.
yes,
Any questions for that applicant? Thank you.
thank you.
All right. So, all right, so do we have any other discussion, or do we have a motion?
Ready to motion?
All right,
After review of case number 2024-092, Planning Commission recommends approval of the request for the plat revision for tracks 1A, 1B, and 1C, Shady Grove subdivision by applicant Jones Davis and Associates, consisting of 3 lots zoned AR on approximately 10.01 acres.
do we have a second?
Second.
All right, we have a motion and a second. Any other discussion? Roll call, please.
Commissioner Vidal,
Yes.
Commissioner Kirkley? Yes. Commissioner Stokes?
Yes.
Commissioner White?
Yes.
Commissioner Carter?
Yes.
And Commissioner McGann, yes. Motion passes.
Thank y'all. All right, moving on to our next case, case number 2024-102, a request for conditional use for electronic changeable message sign at 2496 Goodman Road West on land zone 3, C3 by applicant Prentice Mitchell. And again, we will turn this back over to our director.
Thank you. All right, so I'll start with the purpose of the request. The applicant is requesting to construct an LED monument sign on his property for the purpose of advertising his multiple businesses that pop up throughout the year, including but not limited to summer or winter fireworks sales and a haunted house attraction. Since these businesses are seasonal and varying, it makes sense for the applicant to have an electronic sign that can be programmed to advertise different messages throughout the year. So the design of the sign will be 6 feet wide by 6 feet tall, constructed of metal and being on a concrete base. It will be a monument sign which will conform to all sign ordinances mandated by the City of Horn Lake Code of Ordinances. Next slide, please. So what we have here is an example of what the sign would look like for his property as far as like the dimensions and aesthetics and use goes. The applicant has stated to the planning staff that the design of the proposed monument sign will be the same as the one currently existing at 1690 Goodman Road West for Century Car Wash, which was approved through a conditional use permit. And so if you see below, I went to the site personally and, verified that metal with a concrete base, and it's out there, looked through the minutes. It was approved through a conditional use. So I've got one view looking east, one view looking west, and then obviously it's the bottom part's the digital part that's going to have Mr. Mitchell's changeable wording on there, and then the top part would be like a permanent fixture with his own logos or wording on there. Next slide, please. And then I made sure to throw in some angled pictures there too. So you got one view looking southeast, one view looking southwest. And again, this is the style of design being proposed that Mr. Mitchell would use, showing his own wording and his own logos and his own messaging for his lot. Next slide, please. So we have an aerial view of the property. And if anyone's not familiar, this is Goodman Road to the south and then Hurt Road there to the east. Next slide, please. And this shows the current zoning, and I put this in there to show that all parts of the intersection are either C4 or C3. And next slide, please. So I put all this in there so everybody can just familiarize themselves before the meeting what all the regulations were for the conditional use. So if anyone wants to come back to this part, we can come back. Next slide, please. And so go back up one. Yeah, so in number 2, in the actual ordinance, it says that the Planning Commission shall investigate all aspects of the application, giving particular regard to whether the proposed conditional use will substantially increase traffic hazards or congestion, substantially increase fire hazards, adversely affect the character of the neighborhood, adversely affect the general welfare of the city, overtax public utilities or community facilities, or be in conflict with the comprehensive plan. Next slide, please. And so the way we're doing this presentation is one letter for one slide for each letter. So the first one was we have to look and see if this will substantially increase traffic hazards or congestion. So the applicant has asserted that this proposed sign will not increase any traffic hazards or congestion. And so planning staff agrees that due to the fact that there are already laws on sign setbacks, sign flashing and scrolling, sign brightness, and other related restrictions, the presence of an electronic monument sign that conforms to our sign codes will not be a safety hazard. Because obviously, even if this conditional use gets approved, he would still have to turn in a regular sign permit, and we would still match it up to all the ordinances, and we would still have on the sign permit that it's not going to flash, it's not going to scroll, it's going to transition this many seconds. So it's all going to be on the regular sign permit anyway. Next slide, please. So the next one is we have to see if this will substantially increase fire hazards. The applicant asserts that this proposed sign will not substantially increase fire hazards. So planning staff agrees that this electronic sign will not be any more of a risk than any other sign in the city that requires electricity. So if you look all over the city, most of these signs have some electronic aspect to them, and as far as we have noticed and researched, none of them have been a fire hazard. Next slide, please. The next one is, will this adversely affect the character of the neighborhood? The applicant asserts that this proposed sign will not adversely affect the character of the neighborhood. Planning staff agrees with the applicant on this point because the proposed location will be on Goodman Road West, which is essentially zoned to be the main commercial corridor running through Horn Lake. This road is highly concentrated with commercial businesses, many of which have electronic changeable message signs. The lots on either side of and in front of the applicant's property are commercial properties. Although the property behind the applicant's property is residential, the proposed sign will be far from the house on that property and not facing it, as it will be installed along Goodman Road West to be read from that road. Next slide, please. And the next one is, will this adversely affect the general welfare of the city? Planning staff does not believe the sign will adversely affect the general welfare of the city, there does not appear to be any evidence that an electronic changeable message sign of this style has previously had a negative effect on the welfare of the city. Next slide, please. This one is, will this overtax public utilities or community facilities? The applicant asserts that this proposed sign will not overtax public utilities or community facilities. Planning staff agrees that this sign will not overtax public utilities or community facilities. This is generally meant to be discussed for large developments that consume a large volume of resources, such as schools or factories that need costly water or sewer connections. Next slide, please. And finally, we have to see if this will be in conflict with the comprehensive plan. So planning staff believes that this proposed electronic sign will not be in conflict with the current or future comprehensive plan being created. This is usually discussed when considering bigger projects such as those which propose to add or remove roads within the city or take up large amounts of land with land uses that are in conflict with the zoning, land use, or special district goals. We do not see the construction of this sign being in conflict with the current or upcoming comprehensive plan. Next slide, please. So in conclusion, the applicant has noted that there are other electronic changeable message signs in Horn Lake that were approved by the city through conditional use permits, one of which being the Century Car Wash business at 1690 Goodman Road West, and that he should not be denied the same request that was approved for them. He aims to make his sign just as attractive as the one made by Century Car Wash. And planning staff concludes that approving the conditional use of an electronic changeable message sign at this location is a logical way for the applicant to advertise his seasonal businesses, and that there's no apparent reason to believe that there will be negative externalities as a result of the construction of this sign. And that concludes my presentation.
Thank you, Mr. Andrew. So before we open up, I just want to ask so you're saying that the electronic sign does not violate any city ordinances if it's done through conditional use?
So, yes, if this conditional use does get passed by the Planning Commission and the board, the next step would be him turning in a sign permit, which still has to get reviewed by us. Basically, the purpose of the case tonight is, yes, you're going to look at the sign design and sign elements and sign purpose and all that, but the main purpose is the fact that he will be allowed to have the electronic portion.
And this is different from the last time he came before us, where he was wanting to change the ordinances. This is just for his special use for his one property. I mean,
That's correct. Last time Mr. Mitchell was here for a case regarding signs, the purpose of that case was an attempt to get the ordinance changed to make it allowed for all businesses in town. And so since he withdrew that application after the Planning Commission meeting, now he's back with kind of a different goal, and the goal tonight is just to be allowed for his own property to have a conditional use permit to be allowed to have the electronic changeable message part of his sign.
okay. And then my last little question to you, and then I'll open it up, is if I've watched the Board of Aldermen's meetings, that their desire is to have all businesses have signage on their property. Is that correct? Based on the
Yeah,
comments they've
so
made?
as far as I remember, I do believe the aldermen brought up at one or two meetings that it seems like they prefer every business to have some kind of advertising showing that there's a business on that property. So,
Okay.
yes, that does sound correct.
This would be one step toward that goal.
Correct. It would achieve that goal.
Yep. Anyway, I'll open it up to questions for our director.
I have a question. Is there a limit on how many businesses you can operate out of one address?
No, I've never heard of such ordinance limiting how many businesses can be on a property. I'm not aware of any.
So, Andrew, since we don't have an ordinance for that, then that make more sense for him to have a sign that he can promote various businesses, right?
Correct. The alternative would be, since this property has multiple seasonal businesses appearing and going and appearing and going, you're only allowed to have one sign on your property for your business. So if you have multiple businesses that come and go, you would have to construct a monument sign for this business for a few months, tear it down, construct another sign for businesses for a few months, tear it down, construct another sign, which is obviously a waste of money and it's not practical or efficient. So that's where the electronic changeable message sign idea comes into play, is since you have the businesses coming and going, you just change the messaging on the monument sign and just hit a button and it shows fireworks for sale, hit a button, haunted house, hit a button, another business. So it's a practical solution for that.
Any other questions for our director?
I do. Who's going to be responsible for the sign if his conditional use, if that permit's no longer valid? What happens with the sign?
So in that case, I have not experienced a time when a conditional use has expired at my time in the city, just because they're typically given for many, many years, and I've only been here a couple years. But in that case, the planning department does monitor all the conditional uses in the city, and so since we have conditional use permit applications on file, the planning department does monitor the time limit for all businesses with conditional use permits. So in that case, if it were to expire, then simply he wouldn't be able to use it as an electronic changeable message sign. And
Andrew, wouldn't an applicant be notified and have
Yes.
to come back before us to get that extended?
that's correct. And that's the whole purpose of this, it's to get the applicant back to the planning commission and back to the board to see basically, was this conditional use a success or failure? And as far as like the technicalities on like what physically happens to the sign, I mean, obviously it would be non-conforming if it were to stay in use, and then we would handle it from there.
Yeah, go ahead.
Andrew, on the years that I set the board, whenever a conditional use would come before us, we'd usually set it at a 5-year period, and also at the end of the 5-year period. The property cannot change ownership, or the conditional use goes away. So if that needs to be worded like that, that'll protect him and it'll protect us.
Go ahead.
Andrew, how on other digital signs like this, how long did we give those? What do we normally give them?
So interestingly, I meant to print out the minutes for the other case, but if my memory is correct, for the car wash conditional use permit, the board passed their time period to be for the entire existence that business operates as a car wash. Now, almost every other time I've seen a conditional use permit, it has been for a specified amount of years. But when I was looking through the minutes of that case, the board did not specify years. They said for its entire existence as a car wash, which technically is a period of time.
Are any other questions? All right, is the applicant here? He can come up. Just state your name and address for the record, please.
Bernice Mitchell, 3774 Conrail Circle, Horn Lake.
How are you doing this evening, Mr. Mitchell?
I'm good. How you doing, sir?
Doing good. Does anybody have any questions for our applicant?
I have a question. Do you have any idea how many businesses, seasonal businesses, you plan to operate out of that premises?
Right now, I'm at 3.
Three, okay.
I know that the top section won't be changing. Do you have an idea what the top section would be before, and then the bottom would be? I mean, I know the bottoms would be changing as the seasons change, but do you have an overall idea what the top would be?
Yes. It's going to say Horn Lake, something to the effect of a seasonal area for different businesses to be an incubator.
Okay, all right. Any other questions for the applicant?
I do. I'm trying to get my words. You come before us before asking for this, which I know it was different. You wanted it to be for all businesses, but we had said no, and you have to have a special, you have to get this approved, but yet you had one at your business for the 4th of July. So I'm just curious why you feel like you can do that before coming to us and now come to us after the fact. I don't feel like that's very fair.
Well, let me make a couple of clear up a couple of things. When I made my first request, it was not my idea to have the ordinance change for every business. That was a suggestion of Mr. Andrew. Let me just put that out there. I was only concerned about my property, but it went forth the way it went forth, and it was denied. Secondly, there isn't a ordinance currently against mobile advertising in Horn Lake. I didn't need a permit. So I wasn't trying to do anything unfairly. There wasn't a permit needed for a mobile.
It wasn't moving, though. It was parked. Sitting
Okay.
right there at the same intersection that you're asking the sign for. So here I am driving up Goodman Road, coming home from Le Bonheur, and I'm like, where did that come from? So I just don't, I don't know. I just don't think that, I still just, I don't know. I just felt like it was
can you
worth
clear
bringing
that out?
up.
Was there any violations on the property with that, with the way he had it advertised?
I can't make any comments on that. I would have to research the ordinance and read all the definitions and read the meaning of what's a sign, what's advertising, what's a vehicle, what's this or that. I'm not going to make any comments on what a code violation is or isn't if I don't have the ordinance in front of me and pictures or evidence of what was there or not there.
Mr. Andrew, I have Mr. Chair, I have a second question, so you don't have to answer that question. You're over code enforcement. What code enforcement is sent to ask him to take it down if there was any violation?
As far as that goes, we did not have any official code violation case opened on that. To my knowledge, there was no existing code violation regarding that, because my code officers work a certain schedule, and I don't have any of that in my records.
So if there was a violation, pretty much you'll know about it.
Well, there's hundreds of open violation cases all over the city, and so it's just not possible to remember all of them right off the top of my mind. However, what I'm basically trying to say is that I'd rather not make a comment on code violations if I don't have the code cases in front of me and the ordinance in front of me and the code officer's files open in front of me. And the reason why I'm also saying that is because regardless of whatever that was or wasn't, when this case comes to us, we were just concerned with matching the proposal with the design guidelines and the zoning and what's in the ordinance. So it's like, I understand the concern. I totally understand the concern, but our task was just to match up the proposal with the ordinance.
And I
Sure.
appreciate that. I think you've done a good job of doing that.
The car wash is also a permanent building. There's nothing permanent on this land either. So just throwing that out there too. I mean, this was a U-Haul sized truck with digital advertising. So I just wanted to ask the question.
It is correct that the current, Mr. Mitchell's land has no building on it, but the car wash obviously has a building on it. And so when we did our research through the ordinance, there's no ordinance that, as far as we saw, there's no ordinance saying you have to have a building existing on your property, or that you can't have a sign without a building. So we didn't come across that in the ordinance.
All right, appreciate it. Any other questions?
I have a question.
Okay.
As planning commissioners, right, we can call in and report violations, right? And can we? Do we have that authority?
Anybody can.
I know as a citizen, but us personally, that part of our responsibility.
Anybody can call the code enforcement office and report any violation they see.
All right, thank you. Any other questions for the applicant? Go ahead.
Mr. Mitchell,
Yes, sir.
the property that you're putting it on, are you wanting to put it on the east side next to that shop or whatever it is? Or are you wanting to put it on the west side next to the restaurant? Your placement, where are you wanting to put it?
West, east. It's definitely adjacent to the gravel.
Yes, sir, but what I mean is, are you gonna put it in the middle of your property, on your frontage? Or are you gonna put it on the east side next to the shop business? Or are you gonna put it on the west side next to the entrance to the restaurant?
No, next to the shop.
Next to the shop,
Yes,
yes, sir, that's all I need to know, next to the shop.
All right, any other questions for the applicant? Thank you, sir. Okay, now I'm opening this up for a public hearing. Is there anybody that would like to come up and speak? All right, we are going to close the public meeting. Do we have any other discussion? Do we have a motion?
I'll make the motion. All right,
Go
Jimmy.
ahead. Go ahead, Commissioner Stokes.
After review of case number 2024-102, the planning commission recommends approval of the request for a conditional use permit for an electric changeable message sign at 2496 Goodman Road West on land zone C3 by applicant Prentice Mitchell for, as long as it, I guess, as long as it
I do 5 years. Well, or you just talking about as long as he owns the,
as long as he owns the property.
that's fine.
I put the 5.
Oh, there we go. We have a motion. Did you want to, did you want to leave your motion, or did you want to amend it? All right, so we got a motion to approve for 10 years. Do we have a second?
Second.
And we have a motion.
Second.
Okay, we have a motion and a second. Any other discussion? Roll call, please.
Commissioner Kirkley? Commissioner Vidal?
Yes.
Commissioner Stokes?
Yes.
Commissioner White?
Yes.
Commissioner Carter?
No.
Commissioner McGann? No. We have a tie.
So as the chairman and the tie-breaking vote, I vote yes for approval. So your motion is passed. We appreciate it. Thank you. All right, on to case number 2024-098 is a request for a variance for a setback for a detached garage at 2035 Tall Tree Drive on land consisting of 1.06 acres under AR zoning by the landowner Scott Ford. So at this time, I'll turn this back over to our director, Mr. Andrew.
Thank you. So, first up, we have the aerial view of the property. It's there on Tall Tree Drive at 2035 Tall Tree Drive. Next slide, please. This is the zoomed out view. As you can see, it's in the middle of a neighborhood with similarly sized lots. That was the purpose for this view right here. Next slide, please. And so the current zoning is AR zoning, and we'll get into why that's important later. Next slide, please. And so what they're proposing is a new garage, a new detached garage there next to the house. And so just based on the ordinance and the way our applications are, it has to be separated a certain feet away, and then there's setback regulations it also has to follow. And so the current proposal right now we're seeing is the proposed garage would be located 5 feet from the house and 9 feet from the property line. The minimum side yard requirement in the AR zone is 20 feet. The applicant is requesting to allow the 9 feet setback from the property line. And next slide, please. All right, so the proposed garage will be constructed of brick with the roof of architectural shingles, and the dimensions of the garage would be 24 feet by 28 feet. And there's a little sketch there if anyone's curious about the design aspects of it. Next slide, please. All right, so here we have that, this isn't straight from the ordinance, a different set of questions that have to be investigated in order to pass a variance. It says, a variance from the terms of this ordinance shall not be granted unless the Planning Commission makes findings based upon evidence presented to it as follows. That special conditions and circumstances exist which are peculiar to the land, structure, or building involved, and which are not applicable to other land, structures, or buildings in the same district. And B, that literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of this ordinance. C, that special conditions and circumstances do not result from the actions of the applicant. And D, that granting the variance requested will not confer on the applicant any special privilege that is denied by this ordinance to other land, structures, or buildings in the same district. Next slide, please. All right. And then this just goes over the legal advertising requirements. And then next slide, please. Okay, so going to the particular points that the Planning Commission has to investigate tonight. I'll just read letter A again. A variance from the terms of this ordinance shall not be granted unless the Planning Commission makes findings based upon evidence presented to it as follows, that special conditions and circumstances exist which are peculiar to the land, structure, or building involved and which are not applicable to other land, structures, or buildings in the same district. So the applicant's response, we just copy and pasted this straight from the letter into the PowerPoint slide here. Our residence at 2035 Tall Tree Drive is built at its highest elevation, sloping north to front and sloping south to the rear. Placing a new detached garage in a location with the required setback of 20 feet from the property line would require the location to move southeast behind the house. This area is not desirable with a large slope requiring dirt to fill up 8 feet from the rear to the front of the building. This would be a greater expense in site preparation and building materials. Next slide, please. And next one is the Planning Commission has to investigate and see if that the literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same district under the terms of this ordinance. So the applicant's response was that granting this variance allowing home improvement as others within Apple Creek North have also enjoyed and been allowed to have decreased setbacks as seen on the GIS and listed here, which you'll see on the following slides. Next slide, please. And so all these addresses here, this is just in the same exact neighborhood. These are all the properties where there is a detached structure not conforming to our regulations. There are 20 examples of buildings closer to the property line than the required 20 feet in Apple Creek North. So if anybody wants to go back to these, we can. Next slide, please. And here's just a few screenshot examples using DeSoto County GIS where, and the applicant put this together showing the screenshot and the distance of what's not conforming. And as you can see, one property, there's a detached garage 11 feet to the neighbor's property line. There's a structure 3 feet to the property line, one 12 feet to the property line, one 4 feet to the property line, and one 6 feet to the property line. And that's just a few examples that we put on one slide. Next slide, please. So letter C shows that Planning Commission needs to make finding based upon evidence presented to it that special conditions and circumstances do not result from the actions of the applicant. And so the applicant's response to this was the slope and grade of the land is naturally sloped from the original development. So basically the applicant's argument is that they didn't create the slope of the land there, which is the reason for them bringing the variance to us today. Next slide, please. And then letter D is that granting the variance requested will not confer on the applicant any special privilege that is denied by this ordinance to other land structures or buildings in the same district. And so applicant's response was that this being reviewed by Apple Creek North Homeowners Association and being found acceptable and complementary, being of like construction and placement, and as seen in those pictures, the decreased setbacks have been approved in the past. Next slide, please. And those are all the requirements that had to be checked. That concludes my presentation.
Thank you, Andrew. So do we have any questions for our director? All right, is the applicants, if y'all come up and just state your name and address for the record. We appreciate your patience.
My name is Scott Ford, this is Don Ford, and we live at 2035 Tall Tree Drive in Horn Lake.
Does anybody have any questions for the applicants?
You said the homeowners association already pretty much approved, right?
Exactly.
And normally that's why they're in place, they don't restrict it to anybody.
On all those on Tall Trees in Park Place, the back of our properties are towards the lake. And to move it in and behind the house would pretty much eliminate a view of the lake, but moving it 9 foot off the property line in this location, in that area, we don't have fences. And our neighbor's patio, as well as ours, extends 20 feet beyond the back of our house. So having the garage there acts as a form of privacy for both of us. It's an advantage for both of us to, it's not it won't be an eyesore to them, it'll be complimentary to them and us as well. And there's not even more properties in that area that can be developed. And so what we're seeing is 20 years plus, 27 years, I believe, that they've been developing there. And so things have been, it's just in compliance with what's been allowed, which is if it was found to be non-complimentary to another neighbor in that area, then it wouldn't have been approved, as we see there are numbers of them that have been before you in the past.
Mr. Ford, what's your plans with the garage? It's pretty much for parking cars?
Extra space, parking a garage, yes. A vehicle, an ATV, a golf cart, and just, those houses over there are around 2,000 square foot, so we're 3-bedroom houses when they were originally developed with expandable upstairs. Just doesn't allow for a lot of accumulation of things.
Right.
It's really
That
interesting.
need protection from the weather. And that's why the only openings, it did so, my only openings on the garage or towards our side of the property. There won't be an opening towards the neighbor or to the back, because it is for just storage.
Any other questions for the applicant? Okay, y'all can have a seat. And we're going to open up our public part of the hearing. Is there anybody in the public that would like to speak?
Unless the applicant is coming back up as the public.
Yeah, well, they're the ones. All right, so no one's came forward, so we're going to close the public hearing. So do we have any other discussion, or do we have a motion?
I'll make a motion.
All right, we have a motion.
Case number 2024-098 is a request for a variance for the setback for a detached garage at 2035 Tall Tree Drive on land consisting of 1.06 acres under AR zoning by the landowner Scott Ford. The Planning Commission approves the variance for the minimum required side yard setback.
And we have a motion and we have a second. Do we have any other discussion? Roll call, please.
Commissioner Vidal,
Yes.
Commissioner Stokes,
Yes.
Commissioner White,
Yes.
Commissioner Carter,
Yes.
Commissioner McGann, yes. Commissioner Kirkley,
Yes.
and motion passes.
Thank you all. All right, for our next case, we got case number 2024-101 is a proposed text amendment to the Horn Lake Code of Ordinances, Appendix A, Article 5, T2E II. So I'll turn this over to Mr. Andrew.
Thank you. I'll start off showing the current text in our ordinance. So I'll just read off that whole letter E. And this can just be found on our website in the Horn Lake Code of Ordinances. Currently, it states that all dispensaries shall maintain security, including but not limited to number one, monitored after-hours electronic devices to indicate an intruder, i.e. burglar alarm. Number 2, physically present, insured, and bonded armed security during operational hours. And number 3, video surveillance showing all areas of the dispensary, interior and exterior, but excluding bathrooms. So that's the current wording right now. And the only thing being proposed to change is what's in the red letters right there. Next slide, please. All right, and for the proposal, switching from those previous red letters to this one, the new text would say, a physically present, insured, and bonded armed security guard possessing a security guard permit issued by the state during operational hours, or a physically present armed employee of the dispensary possessing a concealed carry firearm permit issued by the state during operational hours. The dispensary shall maintain a current list of the names of its armed employees and provide such list and any changes thereto to the city police department. And so that's that whole case. It's just a proposal to switch one text to another wording. And if anybody wants any background to this, I can probably help a little bit.
Well, I was just going to say, if you could just tell us what prompted it. That's
Yes. So I wasn't there for any of the discussion. If I remember correctly, this was brought to the board somehow by one of the businesses in town, one of the cannabis dispensary businesses in town. And so when they brought it to the board, I think the board had gone into executive session to discuss this, and then later I was informed that it was the board's desire to change the wording based on whatever conversations they had with the business. So that's all the information I have on that. I did not talk to the business owner or applicant or any of that. There is no applicant. So that's probably why there's nobody in the audience. There's technically
this is a
no
city request.
Yes, as far as I understand, this is a city request, but, yes, that is correct.
All right. Do we have any questions for Andrew? Any other questions? All right, so now I've got to open up the public part of the hearing. All right, so we're going to close the public part of the hearing. All right, so do we have any other discussion, or do we have a motion?
I'll make the motion.
All right, go ahead.
After review of case number 2024-101, the Planning Commission recommends approval of the proposed text amendment to the Only Code of Ordinances, Appendix A, Article V, T, 2E, II, replacing the existing text in said place with the below condition, or should I read it?
I don't think it's necessary to read it. You just said it's being
below
replaced with what was
condition.
been presented.
That'll work.
All right, so we have a motion. Do we have a second?
Second.
A motion and a second. Any other discussion? Roll call, please.
Commissioner Kirkley?
Yes.
Commissioner Vidal?
Yes.
Commissioner Stokes?
Yes.
Commissioner White?
Yes.
Commissioner Carter?
No.
Commissioner McGann? Yes. Motion passes 5-1.
All right, and that concludes all of our new business.
Before we close,
What?
Before we close, I want to point out something that may be incorrect on the prior minutes, if I
Okay.
can. It's on the last page.
Let Andrew know
I
we
just
can
want to
have
see
that.
if it's correct. It just seemed incorrect right here. It failed 2-1, but it said approves.
Right, the motion was to approve,
Okay,
and then that motion failed.
okay. I just wanted to clarify that, so it is correct. Okay, I just want to make sure. Okay.
All right, if there is no other,
Thank you.
if there's no other business, do you have anything else for us, Andrew?
No, I do not.
All right, do we have a motion to adjourn? All right, do we have a second? Okay, we have a motion and a second. All in favor, say aye.
Hi.
All right, we are adjourned.
I think we're doing good, y'all. When football season starts,